Hi guys, welcome to the fourth lecture of IPC, and as committed we'll talk today about the punishment and its theories, and what is the definition of punishment in the IPC, what are the types of punishments, what are the sayings of famous jurists in the terms of punishment we'll discuss today. So let's start with the concept of punishment, or what what are the typical punishments in IPC, because you have seen in various sections of IPC there is written that imprisonment is there, fine is there, somewhere death penalty is there, somewhere rigorous imprisonment is mentioned. So what exactly is the categorization of these punishments? So we'll not go into much of the details and the types of that. We'll just see first as a basic object of ours that what are the typical types of punishments in IPC. So I'll start from more severe to the less severe. The most severe will be taken first. So the most severe punishment in Indian Penal Code is the death penalty. So the first one is the death penalty. Then the next severe is the imprisonment for life. Then the third one is the imprisonment, and this imprisonment is divided into two categories. One is the rigorous imprisonment, which is with hard labor, and another one is a simple imprisonment with no hard labor. Then apart from the imprisonment, there comes the forfeiture of the property, and the least severe punishment, which is only a fine. And as you might have seen that in Indian IPC at current, the values which are mentioned as a fine are very less. Even I can see in some cases that the fine of merely 100 rupees is mentioned in IPC. So this is a personal belief that these all needs to be revised as per the latest standards, or considering the escalation which has happened since the Indian Penal Code was made. I don't know about the reasoning behind this, but that needs to be changed. So we've seen the typical punishments now, but before going into further detail, we should see what exactly is a punishment. So there is no typical definition given in IPC as such, and the definition which I have worked it out, it is based on the various combinations and various details finds in various literature of law. So we can see that punishment can be seen as a suffering in person or property, okay, which is inflicted by the society on the offender who is adjudged guilty of crime under the law. So again, this definition has again 5 parts. It is broken into 5 parts for the clarity and understanding. The first part is a suffering in person or property. Means the purpose of punishment is to make a pain or suffering to a person who has done a crime in terms of himself, or it can be on any property possessed by him. Then the second point is it is inflicted by the society. Definitely it's a social act, and as I said that the punishment or in criminology it is taken on the name of state. Okay, the third point is on the offender, the person, the accused who is committed or who is suspected of the offense. And the fourth point is who is adjudged guilty. Now the punishment is not given to the suspected offender. The offender is suspected, and the accused is suspected, and when it is decided or it is proved in the court of law that he has done the offense, then the term is mentioned here is as a adjudged guilty, means who is judged as guilty of crime as per the applicable law. So H.L.A. Hart, who is a famous jurist, he defined this idea, these elements in his own words, but the crux remains the same. He said he defined punishment in terms of 5 elements, and those 5 elements are: the first element is that it must involve pain or other unpleasant consequences. There must be a pain to a person who is undergoing a punishment. Okay, the second element he says is for an offense against legal rules. So the first element as per him is the pain, the second is the offense, the third important element as per H.L.A. Hart is for an actual or supposed offender for his offense. The fourth important element is the intentionally administered by human beings other than the offender. Means it is taken on the name of society, so it is administered by although the direct administration through the court, but it is considered that it is administered by the society. And the last element is administered by a legal authority, which is a court of law, against which offense is committed. So if you compare the definition which I presented and what H.L.A. Hart's idea is, they both are matching. There are essentially 5 elements of punishment which are discussed. So now this all interpretation of H.L.A. Hart and others, it is criticized by Plato. Plato, the jurist which is remembered from the natural law school. So the Plato, he criticized the overall concept of punishment. He told nothing is like punishment. Let it be realistic, and that's why when we go to the theories, we'll see that Plato has supported the retributive theory of punishment, which is an eye for an eye. So he believed in that. So that's why he criticized the concept of punishment. He says that the concept of punishment, it has only an instrumental value. It's not everything. It's not the required thing. It is not sufficient. It's not a necessary cure. It's, if you see based on the necessity, it is just having an instrumental value. And he very beautifully described that in words. He says that it is no more evil than the bitter medicine which a physician might administer to treat a cure. So its significance or its value is just up to that example what he is given. Okay, so this is a criticism of the concept of punishment, but if we see based on the various theories of punishment, we'll come to know that what various jurists have thought and which theory is applicable in what scenarios in modern legislation. So the first one is the retributive theory, which we just seen in the case of Plato. This theory says that the retributive theory says that the punishment should be an eye for an eye, or jurists take neither as a revenge nor public disapproval of offender's conduct, but as a means for him to realize the justice of his punishment. So the idea behind the retributive theory is that the eye for an eye, so that the offender will understand the sincerity or the seriousness of the justice, or the level of the punishment which he is going to receive, or the level of offense what he has committed. So this theory has seen huge criticism. There are three famous jurists who has criticized this, and some of them have supported this also, that we'll see. So the first criticizer was Sheldon. He told that this theory is uneconomical and unjust. You cannot take an eye just for that the person has taken your eye. Then there is another jurist, Ashwin Work. He gave a beautiful statement about this theory. He told that the person suffers a penalty is lost forever. So in principle, he opposed the theory of punishment itself. Then there is a famous jurist Salmond. He says that it is an inadmissible concept. But if you see, there are other jurists like H.S. Gower and Plato who has supported this. We have seen the Plato's example. Now Stephen, which is a famous jurist, he held this theory as morally right, and he gave a very beautiful statement in supporting this theory. He said that criminal law to revenge is same as a marriage to sexual appetite. So it is necessary. So the revenge is very much needed in criminal law. Although this theory is subject to huge criticism, and the another theory which we are going to discuss now, which is the deterrent theory, it is the having almost the same value as the retributive theory. But the fact is that the deterrent theory, it is resulting in the form of severe punishments or public executions, which are being seen in couple of countries as on today. So deterrent theory, the purpose of this theory is to deter the criminal or any prospective offender from committing any crime. So that was the purpose, and for establishing this purpose, this theory deals with the public executions or severe punishments. This theory was criticized by Holmes, the famous jurist. He said that this theory is immoral because he gave the reason that you cannot be so serious in giving the severe punishments, and also in this way, if you decide or if you take up the judgment like this, this becomes immoral because the decision will become the matter of the subjective opinions of the lawgivers, because their opinions will be different, and the one who will be deciding such a severe punishment based on his observations, then definitely there will be a difference in the manner of the punishments as well as the measure of the punishments. And at the same time, he told that this theory is not relevant because it does not account the offenses which are the result of the provocation, heat of the moment and excitement. So it just talks about the punishment and in a deterrent manner, but it never talks about why that has happened. It may be because of any act of private defense, provocation, heat of moment and excitement. These factors remain unaccounted in this method of punishment. So that is the drawback of this, and because of this drawback, this is proved insufficient in checking the crime. Another important theory, the third theory, which is preventive theory. This preventive theory is supported by Salmon, but the point is that this theory is not completely applicable, because it only covers the preliminary crimes, which are inchoate crimes, which are not complete crimes, like abetment, conspiracy, or attempt. So such crimes, which are preliminary crimes, it can address those only in an efficient manner. And hence, because this addresses only the preliminary crimes, this theory in modern times, it is non-punitive. So all the punishment in preventive theory are belonging to non-punitive nature, and those punishments can be any suspension or cancellation of any license, any forfeiture of any office or any property, and it can be any preventive detention. Means all such punishments which are not of non-punitive nature are covered in preventive theory, because it deals with the preliminary crimes and not the whole crimes, although Salmon has supported this theory. The fourth important theory is expiatory theory, or the theory of penance. So this expiatory theory, the source of this theory is much of the Hindu literature and the mythology, Hindu mythology. So here we can see what was the source. So from Manu, Manu has given a very beautiful statement to which is considered as the origin of this theory. What Manu has said, that men who are guilty of crimes, when they are condemned by the king, they became pure, and then they go to heaven in the same way as a good and virtuous man go. So here he gave the importance to the condemning by the king, that if somebody does a crime and just the king condemns him, then he becomes pure and he goes to heaven like a virtuous man. Like that way he justified the principle of expiation. Similarly, other Hindu jurists, they also signified the importance of expiation or penance, and they told that these two things, they washes away the sin. But in modern times, this theory has no relevance, and all the jurists, they considered it as a sister of retributive theory only. They relate it. This theory is supported by Kohler and Salmon, but again it is criticized by the Holmes, the gentleman who criticized the deterrent theory. He is not convinced with this theory also. And that is a fact, because in this theory, the main limitation is that it is tough to ascertain what is the equivalent of a guilt in terms of suffering. You can relate it mythologically, you can relate it with God, but when it comes to punishment, it has to be realistic. That is missing in this theory. So that is again the drawback of this theory. Now comes the fifth theory, which is very much relevant in today's scenario, and which is having less criticism, which is the reformative theory. It is also called a corrective or rehabilitative theory, because this deals with restoring a person back to a society, rather a offender or accused back to the society as a better or wiser person and as a good citizen. That is the purpose of this theory, which is very much relevant in today's scenario. So the theory aims to make a person or a criminal harmless by two methods. First one is supplying him what he lacks. What he was not having, give that to him so that he can be improved. And the important point is to cure him for those drawbacks which made him to commit the crime. So this way you are deterring him very politely not to repeat the crime, and at the same time you are giving him what he lacks. So you are in fact improving a person. But it sounds so good, but in practicality it also has huge limitations. The very first limitation is, what about habitual offenders? How you will address those? It has a doubtful utility in case of habitual offenders, which are habitual of making offenses. They don't want to get improved. They will just use it. And if we believe in this correction or restoring a man back to the society, then what will be happening to our prisons? Our prisons will be converted to dwelling houses. People will come, they will enjoy there, because they know you are not going to penalize them, and you are going to make them a better human. You will educate them, you will give them something which they lacked, so they will just enjoy, and the prisons will be converting to the dwelling houses. And there is a famous jurist, Professor Hall. He gave a very big question about this theory. He told if whether corrective treatment, which is mentioned in this theory, it should be wholly free from punitive element, because it seems there is no punitive element in this. Then what is the relevance? Why we can call it as a punishment? It's no more a punishment. So in modern times, where it is used, it has utility in some of the cases, but not in all. Like juvenile offenders, the one which are minors, you cannot treat them, you cannot give them that level of punishment which is given to the other professional criminals. So in that case, you will just apply this on juvenile offenders, and then it can be of some substance. Now, for sexual offenders, yes, it can be applicable. But again, the prime criticism, you can apply it anywhere, but the prime criticism of this theory is that the idea of punishment. The idea of punishment is meant to have an unpleasant experience, a pain or suffering on a person, on his property. But here it's missing, because here the punishment is accidentally pleasant for him, because he's having what he lacked, and at the same time there is nothing called punishment here. So the last one, the sixth theory, is the multiple approach theory. What we do, we combined one or two approaches here to make it effective, and that is something which really makes sense. But it needs to be done wisely, because it depends on the limitations of the jurisdiction of different countries, and also what is the permissible level of punishment if you add two or more punishment theories. So this is an example I would like to give with a case law in this multiple approach theory. There is a case with R. Sasikala versus State of Andhra Pradesh. It is a Supreme Court case of 2017 from Indian jurisdiction, where what Supreme Court did, it restored the decision of 1 year rigorous imprisonment, and along with that he made a fine of rupees 5,000, and this was made on an offender who threw acid on the victim. So here the multiple approaches were seen. So such an example, I personally believe that there must be a mix of reformative theory as well as multiple approach theory in the society. And very proudly we can see in Indian legislation, it is seen that multiple approach is being used very widely. And at the same time, at some cases, like as we discussed that in cases of juvenile offenders or sexual offenders and all, the reformative theory has really some relevance. So this was all about the various theories of punishments, and then the types of punishments, and the idea of the punishment, the definition, the elements, and the interpretation by various jurists. So this is all for this. See you later. Bye, and have a nice day. Thank you.